Dear viewers, welcome to the course on Law of Property. I am Dr. Jatin Kalon from Institute of Law, Kurukshetra University, Kurukshetra. Today we are going to discuss doctrine of part performance. Let us start with the introduction. Part performance in law, specifically in relation to contracts and real estate, pertains to the incomplete fulfillment of contractual duties or the implementation of actions that demonstrate a commitment to carrying out a contract. The legal principle in question is of utmost importance in safeguarding the interests of parties engaged in contractual agreements. It ensures that appropriate measures are taken and acknowledgements are made in cases when the contract is not entirely fulfilled, thereby offering remedies and recognition for partial compliance. This study will specifically examine the conceptual comprehension of the legal principle part performance in relation to the different laws in India. Let us now briefly look at the jurisprudence and historical metamorphosis of the concept. The notion of part performance has a long-standing historical foundation. It stems from the necessity of upholding equality and impartiality in contractual associations. Historical legal systems acknowledged that rigid execution of contractual agreements could result in unfairness when one party fulfilled their obligations but had no means of redress if the other party neglected their responsibilities. The notion of part performance, which ensures fairness, has been developed as a solution to rectify these disparities. The legal basis of part performance developed and changed over time in response to societal changes and shifts in legal theories. Equitable concepts such as part performance have become prominent in common law jurisdictions with the goal of preventing unfair enrichment and fostering fairness in commercial transactions. Now, looking at the evolutionary progression of the doctrine of part performance, in equity and common law, the origin of concept of part performance can be traced back to equity, a legal system that sought to address the shortcomings of common law. Equity courts acknowledged that strict adherence to contractual formalities could result in unfairness, and hence they granted remedies in situations involving partial fulfillment. Now, in the process of statutory codification, the ideas of part performance were subsequently incorporated into statutes in several jurisdictions. An example of this is the Statute of Frauds in England, which was established in 1677 and mandated that specific contracts, particularly those pertaining to land, must be documented in written form. However, exceptions were made for part performance, allowing courts to enforce oral agreements when one party had significantly relied on and performed its obligations. In modern contract law of today, part performance is a well-established concept in contract law, and its principles are embedded in various legal systems worldwide. Courts recognize that strict adherence to formalities may not always serve justice, and consideration of fairness and good faith play a crucial role in determining the enforceability of contractual arrangements. Now, let us look at the laws related to part performance in India. So, there exists no specific provision which concerns solely to the doctrine of part performance in India. However, this doctrine is contextually concomitant with the provisions related to property and contract. To begin with, let us look at the doctrine through the lens of various legislations in India. Firstly, we'll have a look at the Indian Contract Act. It is the mandate of the Indian Contract Act that the parties need to perform their promises unless otherwise is agreed amongst them. Under section 37 of the Contract Act, it is stated, and I quote, that the parties to a contract must either perform or offer to perform their respected promises unless such performance is dispensed with or excused under the provisions of this Act or of any other law. Hence, to begin with, it is the obligation of the parties to perform or offer to perform the promises that they have made to each other, unless there exists any other intention amongst them. The road to part performance can be said to originate from this provision. As discussed above, the doctrine of part performance was evolved by the Court of Equity in England 1677, a statute of frauds in order to prevent the perpetuation of fraud in the transfers of land. Hence, this doctrine was also known as equity of part performance. Madison versus Alderson, which established the part performance doctrine in England. In this case, Lord Selborne observed, and I quote, that in a suit founded on part performance, the defendant is really charged upon the equities resulting from the acts done in execution of the contract and not upon the contract itself. If such equities were excluded, the injustice of a kind which the statute cannot be thought to have had in contemplation would follow. So in 1906, the Madras High Court in the case of Kuri Vera Reddy versus Kuri Bapi Reddy held that Indian law did not apply the English concept of part performance. But in 1914, it was held by the Privy Council in the case of Muhammad Musa versus Aghor Kumar Ganguly that part performance doctrine was applicable in India on the account of justice, equity and good conscience. Now let us look at another very important legislation, which is the Specific Relief Act. The jurisprudence of justice, equity and good conscience is also reflected in section 12 of the Specific Relief Act. According to section 12 subsection 2, if a party to a contract fails to perform a portion of the agreement that bears only a small proportion of the whole value, which can be estimated in monetary compensation, then the court may, upon filing of a suit by either party, order specific performance of that portion of the contract and also award monetary compensation to the party whose damage is caused. According to section 12 subsection 3, the party bringing the lawsuit is not entitled to a decree for specific performance of the contract when one or both parties to it are unable to perform the whole or a portion of it, and where payment in cash can be estimated or not, there is a provision. Number 1. The party in default consents to carry out the portion of the contract that remains unfulfilled by paying compensation in cash for the entire contract. Of course, it should be minus the consideration amount for the portion that remains unfulfilled. The second proviso states that the party has consented to pay the compensation in cash without any reduction in its value. Or proviso number 3 states that by virtue of the default, the defendant waives all claims to the performance of the portion of the contract that remains unfulfilled, and also to encash any compensation for any loss or damages incurred by him. And then we have the last proviso, proviso number 4, which states that when a contract is divided into independent, separate sections which form another part of the same contract and which cannot or ought not to be specifically performed, then the court may direct specific performance of the former part. In India, the Transfer of Property Act 1882 specifically addresses part performance in the context of contracts related to immovable property. Section 53A of the Act provides protection to transferees in possession under an oral agreement for transfer of immovable property, even if the agreement is not registered. Now, talking specifically about Transfer of Property Act, according to the doctrine of part performance vis-a-vis property, an individual who has obtained possession of an immovable property through an unregistered sale and has fulfilled or is prepared to fulfill their share of the contract, they cannot be removed from the property, even if the legal title has not been transferred to them. The foundation of this philosophy is the idea that equity considers action taken rather than actions that should have been taken. The Transfer of Property Act specifically deals with the concept of part performance in contracts related to immovable property. As we have discussed above, This pertains to situations in which an oral agreement for the transfer of real estate is officially not recorded. Section 53A provides protection to transferees who are in possession of the property under such an agreement. Doctrine of part performance is an equitable doctrine. It is also called equity of part performance. According to this doctrine, if a person has taken a possession of an immovable property on the basis of a contract of sale and has either performed or is willing to perform his part of the contract, then he cannot be disposed from the property on the ground that the sale is not complete and the title has not been passed. Section 53A seeks to protect the prospective transferees and allow them to retain the possession of the property as against those transferors who, after executing an incomplete instrument of transfer, fail to complete it in the manner specified by law, without there being any fault on the part of the transferee. Let us take an example. A and B enter into a contract of sale for a property X. The contract of sale is in writing but not registered. On the basis of contract of sale, B takes the possession of the property X. He is ready and willing to perform his part of the promise. Now, A sells the land to C through the registered sale deed. The legal title of the land passes to C. Now, C attempts to eject B from the land on the basis of his legal title. Here, B had the legal title, so according to strict provision of law, he may not be able to protest his possession. But by nature of this equitable doctrine of part performance, he will be able to protect his possession. Equity of part performance was developed by chancery courts in England. In England, equity protected the interest of those persons who held the land on the basis of an oral contract, and they also performed their part of the contract. Section 53A incorporates the doctrine of that part performance. This section was inserted by an amendment in 1929. Section 53A is more limited than English equitable doctrine of part performance. Let us look at the provisions, the nitty-gritties of Section 53A. The first point is that where a person contracts to transfer an immovable property for consideration by writing signed by him, the second condition is that the transferee has taken possession over a part or whole of property acting in furtherance of that contract. The third condition is that if they have already in possession, they continue to be in possession and they do some act in furtherance of that contract. And lastly, that such transferee has either performed his part or is willing to perform it. Then although the transfer is not made according to the prescribed process of the law, the transferor or any other person, they cannot be dispossessed by the transferee. Now let us have a look over the position of Section 53A prior to 1929. Prior to insertion of Section 53A, the application of doctrine of part performance in India was neither certain nor uniform. High courts in India had conflicting views regarding applicability of the doctrine. The matter came up for consideration before Privy Council, as we have discussed in the case of Muhammad Musa versus Aghor Kumar Ganguly. Now let us look at this case in a more detailed fashion. In this case, a compromise was entered into between the parties. By virtue of the compromise, they agreed to pay off certain debt and divide the property into specific shares. No conveyance was executed in pursuance of the compromise, but parties took possession of their shares and enjoyed that in accordance with that compromise. Nearly after 40 years, heirs of the parties tried to repudiate the compromise on the basis that it was not registered. Privy Council applied the doctrine of part performance as laid down in English case of Madison versus Alderson. The question of applicability of this doctrine came up in another case of Arif versus Jadunath. In this case, the plaintiff Arif agreed to grant permanent lease to Jadunath in 1913 on a certain monthly rent. It was an oral agreement and the lease was neither executed nor registered. In 1922, Arif gave a notice to Jadunath to quit the land and subsequently filed a suit in 1923 against Jadunath for ejectment. The Calcutta High Court relied on the doctrine of part performance and dismissed the suit. On appeal, the decision was reversed by Privy Council. Privy Council held that the doctrine of part performance cannot be applied to override express provisions of the statute, and permanent lease can only be granted by means of registered instrument, and therefore doctrine of part performance would not apply here. The position of law was further made clear by another case and by Privy Council in Mia Pir Bucks versus Sardar Muhammad Tahir. Therefore, Arif's case and Mia Pir Bucks's case made it very clear that equitable doctrine of part performance cannot override the express provisions of the statute. Now let us also look at the essential conditions for the applicability of section 53A. The first point which must be fulfilled is that there must be a written contract for the transfer of an immovable property for consideration. There has to be a written contract. The second condition states that the contract must be registered. The third condition states that the transferee must take possession of the property. The last condition states that the transferee should either perform his part of contract or is willing to perform the same. Now let us discuss all these conditions in a more detailed fashion. First is the written contract. So the contract for transfer of an immovable property must be written. If the contract is oral, then section 53A is not applicable. This contract must be duly executed, that is, duly signed by the transferor. This contract must clearly suggest transfer of property. Transfer here means transfer of property according to section 5 of the Act. It is also necessary that the transfer must be for consideration. The terms of the transfer must be clear and not ambiguous. The property must be immovable property, and the provision is not applicable to an agreement for transfer of movable property. The second condition is that the contract must be registered. An unregistered contract of transfer will have no effect for the purpose of section 53A. In this regard, an amendment has been made in section 53A by the Registration and Other Related Laws Act of 2001. This amending act has also amended section 17 and section 49 of the Registration Act. The current position after the amendment is that the documents containing contracts to transfer an immovable property for consideration of the purpose of section 53A must be registered if they have been executed on or after 24th September 2001. If such documents are not registered, then they shall have no effect for the purposes of section 53A. The next condition is that the transferee must take the possession of the property. The doctrine of part performance of contract defends the possession of the transferee. Therefore, it is essential that the possession must be taken on the basis of the contract. If the person remains in possession, even on the part of the property, then it is sufficient compliance of this section. If the person is already in possession of property prior to the contract of transfer, then he must do some further act in part performance of the contract. For example, a payment of price. There must be direct relationship between the further act done and the contract. The next condition is that the transferee has either performed his part or is willing to perform the same. The basis of doctrine of part performance is equity, as discussed before. Therefore, equitable principles are also applicable to the person who is claiming the benefit of this section. His conduct must also be equitable because he who sees equity must do equity. In this sense, the person who wishes to take benefit of doctrine of part performance must either perform his part of the contract or must be willing to perform the same. Such willingness should subsist till the decision of the court. Court infers the willingness from the conduct of the parties. Now let us look at the nature of transferee's rights under section 53A. The first point here which should be noted is that the transferee should hold no title or interest in the property. Section 53A does not confer any title or interest to the transferee except the right to continue his possession. The doctrine only protects the possession. The next nature, which is the passive equity, it is not a right of action. So in India, the equity of part performance is a passive equity. It can only be used as a shield and not as a sword. Section 53A does not give to the transferee any right of action. It only provides a right of defense. Transferee cannot restrain from the transferor from transferring the property to any other person. Now the Privy Council, in the case of Prabodh Kumar Das versus Dantamara Tea Corporation Limited, held that equity of part performance is applicable in India. It is not an active equity. The right available under this section is to protect only the possession. The next nature that we are going to discuss is the transferee, whether they will be able to get the benefit as a plaintiff or as a defendant. The opinions on this matter from various high courts are divided. The high courts of Allahabad, Bombay and Andhra Pradesh have opinion that the transferee may also be a plaintiff, whereas the high courts of Rajasthan, Odisha, Madras, Punjab and Haryana high courts, they have the opinion that the transferee has to protect his possession only as a defendant. However, the main point is defense of possession, and it is completely irrelevant whether the transferee acts as a plaintiff or as a defendant. Now let us discuss the provisos to section 53A, which talks about the rights of subsequent transferee for the value. The proviso to section 53A protects the interest of a subsequent transferee for value without notice of previous transferee's rights to part performance. The transferor can transfer the property to a subsequent transferee, and if such subsequent transferee has absolutely no knowledge of the previous contract, then section 53A shall not apply to such subsequent transferee. Now let us conclude our observations. Ultimately, the notion of part performance in law has developed in order to address the requirement for impartiality and justice in contractual associations. The historical evolution of this concept demonstrates an acknowledgement that rigid adherence to formalities might result in unfairness, particularly when one side has already completed some of its obligations. The idea of part performance in India is supported by section 53A of the Transfer of Property Act, section 37 of the Indian Contract Act and section 12 of the Specific Relief Act. As legal systems evolve in response to societal developments, the concepts of part performance remain crucial in upholding justice and fairness in contractual transactions. That is all for today's lecture. See you in the next module. Till then, thank you. Goodbye.